Minutes after 7, so it's time to start. And at the outset, I want to let everyone know that this meeting is being cablecast by Area 58, Community Access Media, Channel 15, and as always, we're happy to have them with us this evening. We have a couple of administrative matters to address before we begin the major order of business for this evening. Part A of our agenda, discussion and vote relative to reorganization of the Town of Carver ZBA. We're in a new fiscal year, so we do this annually, or try to remember to do it annually. And I ask any one of you members who would like to be heard on this particular issue as to who our officers should be for the upcoming fiscal year. Pleased to recognize anybody who wants to speak on this.
I like the officers the way they are.
Second.
Can that be put in the form of a motion?
I move that we re-elect Stephen Gray as chairman of the zoning board of appeals.
Can I not convince any one of you to take this chair?
Not a chance.
I've kept it warm for you.
It's the pins in the chair that I have problems with.
I'll second that motion.
Ms. Clark, would you call the roll? Ask for a vote.
All in favor of retaining Stephen Gray as our chairman, say aye, please. Aye. Sorry, Guy.
I would like to nominate Sharon Clark as our vice chair.
That's a good pick. I'll second that too. Yeah.
Anybody wish to be heard on this? Hearing no discussion, all in favor of this motion?
Aye.
We are reorganized for this fiscal year. Congratulations to Ms. Clark.
Right back at you, buddy.
Let me skip to C for a minute on our agenda, which is the discussion and possible vote to accept minutes. First, the minutes of June 9, 2016. I always try to get these minutes to you folks well ahead, as you know. And I ask first that whether each and every one of you has had an opportunity to look at those June 9, 2016 minutes.
I have.
Do I hear a motion to accept those minutes as written? Or does anybody have any changes or amendments or modifications they'd like to make?
Good. Make a motion to accept the minutes as written.
Do I hear a second?
Second.
Any discussion? All in favor?
Aye.
Those minutes of June 9, 2016 are accepted. Now we move to the minutes of June 23, 2016. And I ask if anybody has not had an opportunity to review those, or has everybody at least had a chance to review those ahead of time? I've sent these around as well. Anybody want to make any changes, amendments, or modifications?
Good.
Do I hear a motion to accept?
I'll make a motion to accept the minutes of June 23rd as written.
Second.
Any further discussion on this? Hearing none, all in favor?
Aye.
Those minutes of
I'm abstaining.
June 23, 2016 are now accepted. Next, we move to the major order of business for this evening, which is a continuation of a public hearing that seems like it was started ages ago, doesn't it? This is a request for a comprehensive permit, the petitioner being Draper Home Developments LLC off of Plymouth Street, Carver. That's the location of the requested project. It's located on Assessors Map 18-Lot 8, and the petitioner is requesting a comprehensive permit pursuant to 760 CMR 56 in order to develop a 39-lot subdivision on 17.81 acres in a residential agricultural district shown on map 18-Lot 8.
Mr. Chairman,
Yes, sir.
I wish to recuse myself on the grounds that I was not present for the initial meetings on this case.
You'll be missed.
Well, if I may, Mr. Chairman,
Yes.
under the Mullen Rule, if your member wants to still participate, they can look at the tape or look at the minutes. The Mullen Rule would allow him to continue to participate. I'm not trying to tell you business, but the Mullen Rule provides for exactly this circumstance. 'Cause we've only had one partial hearing.
Right. Mr. Nowen, would you stand? I want to ask you, would you prefer not to sit on this case at this point in time?
You know, I think it would take quite a bit of catching up to bring myself up.
Very well. Thank you for that.
Well, just for the record, Mr. Chairman,
Yes.
nothing substantive has really happened so far. We didn't put in the plans. We argued about some procedural things. No offense to you, but nothing substantive has happened.
I understand that.
I'm not trying to tell the member or the
I
board,
understand that, but
for the
his-
record,
His decision is to recuse himself on this case, and I will accept that decision. And Ms. Mello, who I assure you is eminently qualified and has been a member of this board for years, will be sitting as a member, voting member on this case. Thank you. Now, yes. Yes.
For the record, I would like everyone to understand that the town of Carver has not adopted the Mullins Rule.
Mullen Rule is a law, is a legal, it was a case decided under common law, which allows any board,
It is a local adoption.
I appreciate it. Okay, my experience is that no town has not adopted it or used it, but having said that, you're free to constitute your board.
From one
as you see
attorney
fit.
to another, I respect your position. I understand exactly what you're saying. Not taking a position with regard to the Mullen Rule one way or the other. What I am doing is supporting Member Nowen's decision to recuse himself in this case. Ms. Mello will assume his seat as a voting member on this particular petition. And I think that disposes of that issue. Now, because it's been so long, April, since we had our initial public hearing on this, I think it might be a good idea for me briefly to talk to you all here tonight, and also those watching at home, give a little public education, if you will, about these 40B petitions. This is Carver's first. And 40B refers to Massachusetts General Laws, Chapter 40B. And this is the particular chapter and section of the Massachusetts General Laws that refers to comprehensive permits. And under the comprehensive permitting scheme of Chapter 40B, a developer can obtain all of the local permits and approvals necessary for an affordable housing project through a single application filed with the Zoning Board of Appeals in the town. Now, the statute allows developers of affordable housing to bypass local bylaws and ordinances, including zoning bylaws and subdivision rules and regulations, and local wetlands bylaws, but excluding state wetlands regulations and Title V Sanitary Code provisions, which hinder the development of affordable housing. Now, a key percentage for everyone to keep in mind is 10%. Carver does not have 10% or more of its housing stock qualified as affordable housing, as defined by state regulation. So in instances where a town is under 10%, The zoning board in that particular town must generally grant whatever waivers are necessary to make a project economic. However, zoning boards do have the right to weigh these requests for waivers against any local concerns, such as threats to public health, safety, or the environment. This is what we lawyers call a rebuttable presumption. It's a presumption in favor, but that presumption is rebuttable if local concerns are significant enough to outweigh the presumption that affordable housing outweighs these local concerns because that municipality is under the 10% threshold. And I should also point out to everybody that this is a very heavy burden for opponents of 40B projects to carry. They must demonstrate again that local concerns outweigh the need for affordable housing when we're under that 10% threshold. Now, before I go any further, I think it, again, might be useful to introduce to all of you the members up here who will be sitting on this case, as it has generated so much public interest. To my far left in the pink shirt is Fran Mello, who has many years of experience in the business world on a management level. And as you just heard on that back and forth with regard to Mr. Nowen recusing himself, Ms. Mello has been with us now for how many years?
4 years.
4 years. To my immediate left is Stephen Maynard, who's been with us longer than that. Stephen has, for many years, been self-employed in this area as a housing contractor and home improvement person. He's very talented. To my immediate right is our new but old vice chair, Sharon Clark, who is the longest-serving member of the Zoning Board of Appeals. I'm not going to embarrass her by asking how many years, but I know it's many years. And she has a long experience in land use issues and has also many, many years of experience as a title searcher. To her immediate right is Eric Mueller, who also has been with us for many years. Eric was the owner of a septic company in town until he sold that and is now working as district manager for a larger septic company, so he's well-versed on septic issues and Title V issues, which will be important in this case. To his immediate right is Judy Barrett, who is our consultant on this case. She comes to us from Duxbury, where she has been at various points in time chairman of the Board of Appeals in Duxbury and now is the vice chair.
Good for you.
And her experience and her oversight of this whole process for this board is already proved to be invaluable to us. And I have thanked her personally already, and I will, I'm sure, continue to thank her going forward. To her immediate right is our town planner, Marlene McCollum. Now, at our last meeting, concerns were raised regarding the incompleteness of the developer's plans as then filed and the information provided by the developer to the board. Specifics of these informational deficiencies were summed up in a memo of the town planner dated April 7, 2016, which was read into and made part of the record with copies given to the attorney for the developer at that time, as well as the attorney for the neighbors in opposition. The chair observes that the concerns raised in this memo are very similar to those raised by Attorney Glick, the attorney for the neighbors in opposition, in his previous letter to me dated February 26, 2016, and to the chairman of the Board of Health dated March 3, 2016. So at our last meeting, we directed the developer to provide augmented and detailed information to the board in accordance with the concerns raised in the memo of the town planner, so that we could begin an intelligent and careful analysis of the facts as they apply to the pertinent law. Also, the board voted at that time to establish a subcommittee to help it select its peer review experts, because with a project of this kind and with the technical issues involved, it is customary for boards of appeal to reach out and hire peer reviewers so that we can be given appropriate guidance and information. Now, that meeting has occurred, and you will hear from Ms. Clark, who participated in that meeting, shortly. Mr. Maynard, to my left, was also involved in that meeting on behalf of the board. So as we proceed tonight and beyond, I want everyone to understand that there will obviously be many questions and concerns raised by the various members of the board up here. And to those listening, it might indicate to the unpracticed ear that we could be sympathizing with or leaning in favor of one party or the other. I urge you not to try to handicap us in this regard. After having appeared before many boards and courts, including the Supreme Court, I can tell you that trying to guess what's in the head of the judges who are hearing a case is a dangerous enterprise. And I have been chagrined many times by some of the decisions that have come back on my own cases. Lastly, the Zoning Board of Appeals, I want everyone to know, is no stranger to controversial cases. We've had some wing-dingers over the years. However, understand we are not a political board. We do not set policy. We are a quasi-judicial board. We sit as 5 judges, and we do our level best to sort out the facts and apply them to the applicable law wherever that might take us, regardless of whether our ultimate decision is popular or not. So I hope this little primer has been helpful and hope it's refreshed some memories, because again, our last meeting on this particular case now goes back to April. Now, the first thing that I'd like to ask the board to consider is an extension of the 180-day clock. I thank Mr. Kraus for sending an email out on April 8th, one day after our last meeting, granting or agreeing to the 180-day extension. This 180-day extension that we're talking about, ladies and gentlemen, has to do with the fact that after a public hearing is opened, we have 180 days as a board to render a decision, unless that is by agreement extended. And Mr. Kraus, because of the informational deficiencies identified back in April with regard to the petitioner's plans, has graciously agreed to extend the 180 days, beginning as of tonight, July 21, 2016, which gives us roughly until January of next year to make a decision, if we need all that time. So I ask the board for its comments or questions with regard to this. If there are none, I would ask for a motion to accept the extension offered by Mr. Kraus on behalf of the developer. Anybody have anything that they want to say on this?
So just to be clear, the 180 days starts today.
Today,
Okay.
And would expire therefore on January 16th.
2017.
Yeah, we had extensive discussions on this the last time. I'm fine with it.
Does anyone else have anything they'd like to say on this? Do I hear a motion?
I'll make a motion to accept the extension for 180 days, beginning today, July 21st.
Do I hear a second?
I'll second.
Any further discussion? Hearing none. All in favor?
Aye.
The next administrative matter that I'd like to discuss with regard to this particular case has to do with the filing of the, I don't want to call them new plans, but the more detailed plans that we had asked be done by June 15th. and I want to ask whether those plans were filed on or before June 15th.
Go ahead,
Anybody
Randy.
speak to me about that? Did the plans come in on or before June 15 as we expected?
They came to Town Hall on June 15th. I believe it was somewhat barely after 4 o'clock. The individual that was bringing them lives in Lakeville, was headed home. There was nobody to accept the plans. He brought them through the next morning.
So they were filed on June 16th.
That would be accurate.
And who was it that was bringing them in on the 15th and found that it was too late?
It was Robert Lucy, also a registered professional land surveyor, works in my office, and I asked him to drop him off on his way home.
Okay. Now, we had our meeting on April 7th, our first meeting on this. Was there not enough time for you to get them in on or before Town Hall closed on June 15th?
I think, sir, that it's fair to say that that was plenty of time to get them in.
Okay.
We dot i's, cross our t's, went through the process. I did have some medical issues come up, but circumstances beyond my control certainly aren't your problem.
Right, so the fact of the matter, Mr. Chairman, is that the plans, as requested, have been in the town hall for more than 30 days.
And Ms. McCollum, is that accurate that they came in a day after and were accepted for filing on the 16th?
Yes, so your copy should be stamped in as received by my department on the 16th of June.
Going forward, and I want to ask the board members about this, whether they believe it would be reasonable for a representative of the planner's office to advise us when there is a date that we are expecting something to be done by, that if it is coming in late, that a representative of the planner's office notify either myself or the vice chair if I'm unavailable.
Makes sense.
Is that something that each and every one of you can support?
I think the more communication we have between all parties involved in the process, the better off everybody's going to be as we try to work our way through this.
I would agree, Mr. Chairman. The technical, if you will, it's form over substance, whether, it got stamped in that day at 4 o'clock or the next day. Email communications have been extensive through all the parties, and I think that is a wise suggestion instead of not understanding why things have been done or why they haven't been done. It'd be easier just for email communication because everybody can been shared on it.
Right, and I agree with you wholeheartedly, Mr. Kraus. I think the sense of the board is the same. Is that correct? So, Ms. McCollum, in the event that dates are established or publicized at the public hearing, if filings do come in at a time that would be deemed to be late, that you notify either me or Ms. Clark if I'm unavailable. Is that okay?
Yes.
May we also, since I think we've seen everybody's email on chains, may we also communicate? Is that just by, a shared email with all
Well, I
parties?
think probably best for you to communicate with the planner's office first.
No, we're happy to do that.
And she knows now that she's obligated to send everything out.
I'm just trying to save a step for the planner.
Now, the next matter that I want to discuss, yes,
May I just be heard briefly on that point?
on which point?
The point you just discussed about the late filing?
Yes.
My name's Neil Glick. I'm an attorney for several of the neighbors to this project. I was here at the prior meeting. I believe that there was more that was supposed to be filed by the 15th. Mr. Kraus just said, well, this is form over substance. We got the plans in on the 16th. But we didn't see the waiver requests until, I believe, the 19th. They were received. I'm not sure when they were posted on the website. I only saw them just the other day, just yesterday. I believe there were other matters that were supposed to be of real substance, that were supposed to be provided in addition to the so-called new plans. So it's not just form over substance. And Mr. Kraus says that, well, they've been at town hall for over a month. That's not, the plans have, but the rest of it hasn't. And it's very disturbing that that we're here now, having just seen some very important things come in just on the eve of this hearing.
You have the waivers now, Mr. Glick?
Well, they're posted on the website, yes, I do.
So you've been aware of them now for approximately how long?
24 hours?
I assure you we'll address all of this as we get more into the
Understood.
particulars of the case. But your point is well taken, and I would not have raised the issue of the late plan unless I myself thought it was important enough to raise. For me, I come at this from a little bit of a different angle. This was a discussion that we had back in April in front of a full selectmen's chambers. I think every chair in this place was taken. And the public had an expectation, based on our conversation at that time, that these plans would be filed on or before April 15th. So for me, it's a public information issue. It's something that we expected the petitioner to do, and the petitioner did file, albeit late, and some waivers even later than that. So we'll keep our eye on the ball here, and that's one of the reasons why I went through this exercise up here with the board members and with Ms. McCollum, to make sure that if we do set deadlines and dates going forward, and for some reason there is lassitude on the part of the filing party that puts that party beyond expected dates that were discussed in open public session, that she's going to let me know or Ms. Clark know going forward. Now, the next administrative matter, a site walk. This is an important enough project that I think I want to try to get a site walk scheduled with the board members and with Ms. Barrett, who's giving me the affirmative nod of her head over there, as soon as possible. With the understanding, of course, that this will require some flagging, I would imagine, on the part of the developer, so that we can basically understand what it is that we're looking at. So, what is the sense of the board with regard to whether it wants to do a site walk on this project?
Oh, I think it's imperative.
Can you speak up, please?
I think it's imperative.
That we all heard.
Okay.
Any other comments on this or discussion?
No, agreed. I think it's important.
So, yes, sir. Yes.
I simply have a question and perhaps a suggestion. We would typically stake the center line of the proposed road with stationing, so you could walk the site with a plan and know where you're at. Nothing fancy, 100-foot stations, orange flag, and some magic marker for your reference, if that would be sufficient.
So can we find a date amongst our 5 busy schedules?
Mr. Chairman, I assume someone from the applicant's team would join the board for this in case the board had questions?
Oh, sure, sure. Not any time.
I would presume that Randy and Mr. Draper is
Not any time in the next 2 weeks, people. Can't do it.
I hear vacation.
I can be there, but I don't know
So
that I
maybe
can make it around.
later on in August,
Third weekend of August, maybe?
third
Okay,
weekend.
with me.
When do you typically do your sidewalks on the
Saturday.
weekend?
On Saturday
mornings,
mornings.
yes.
Not around the weekend of the 20th.
You know what?
Around the weekend of the 20th. It's the third weekend.
The 27th.
Eric, why don't we start with you? What weekend works for you? We're talking about a Saturday.
I'm available the 13th
Nope.
or the 27th of August.
27th work for you?
27th works for me.
27th work for you?
I can do the 27th.
Does the 27th work for members of the development team? 27th of August?
August.
Yes.
Yes. It certainly works for us, Mr. Chair. We'll make sure those stakes are there.
And
Before
9
you need
AM
them.
work for everybody on the board? Ms. Barrett?
Yes.
Yes?
That works.
9 AM and just meet on the street there.
So I ask for a motion from a member of the board to approve a site walk on August 27th at 9 a.m.
I so move.
Second.
Any further discussion on this? All in fa-
Could I just ask that where we're gonna gather be marked some way, so, because I'm not quite sure where on Plymouth Street this is located.
Right, well, as we've done with Mass Housing, you'll probably see somebody there, and you'll see the car, and we'll mark it, and you'll recognize someone from this side.
Thank you.
Thank you.
I think we have a motion and a second.
Before the motion is passed, just, and I understand the board's schedules take precedence, and I fully understand that. I do have a conflict on the 27th. If it could be moved up a day or back a day, I'm in court all day on the 27th. But
This is-
Saturday.
It's a Saturday.
It's a Saturday.
If that's not possible, I completely understand.
It's a Saturday?
27th is a Saturday, Mr. Clark.
I'm
Isn't
sorry.
it?
You won't be in court all day.
No, I
Yeah.
won't.
August
You're
27th.
coming from the Boston area, are you? Is 9 o'clock give you enough time to come down?
Right, but, Mr. Chairman, just so that we all understand, the sidewalk is not for taking testimony. It's
No deliberation of this board will take place.
It's just to walk the site.
That's true. Correct. All in favor?
Aye.
So we will have that site walk on August 27th at 9 a.m. of Saturday morning. Next, I want to go to the subcommittee meeting that was held recently with regard to selection of peer reviewers, that whole process. Vice Chair Clark, on behalf of the board, was present, as well as Member Maynard, as well as Ms. Barrett, and the planner was present as well. So 4 people. And I'm going to, at this point, ask Ms. Clark for a report of the subcommittee.
Certainly. I'd like to defer very quickly to Marlene, who can outline the RFQ. I believe the town sent it out to six people, and if she can just give a quick review of the RFQ process and how we came to be, then I'll discuss our deliberations.
Thank you. So the RFQ was sent out to 6 firms, Fuss and O'Neill.
Ms. McCollum, could you move that a little closer so we can pick up your voice better? Thank you.
Fuss and O'Neill received a copy, Comprehensive Environmental, Inc. received a copy, Beals and Thomas, BSC Group, VHB, and Beta Incorporated received a copy. The submissions were due back on June 30th, and the scope of required services included conduct a site visit, review the development plan, stormwater report, wetlands data, and supporting documentation and data from the applicant and applicant's consultants,
Can everybody hear okay? Yep, okay.
review the developer's list of requested waivers and local regulations affected by the request, advise the board as follows: whether all the waivers are essential for the feasibility of the proposed project, whether the applicant has provided enough information to determine whether granting one or more of the waivers would have an adverse impact on a valid health, safety, environmental, design, open space, or other local concern, as that term is defined in 760 CMR 56. If additional information is needed in order to determine B above, identify the information the board should request from the applicant. As necessary, consult with the town staff, the board's MHP consultant, and other peer review consultants who may be engaged by the board. Provide a written report to the board on the applicant's submission. Review the response from the applicant's consultants and provide comments on the same to the board. Provide specific recommendations for mitigation and conditions that should be incorporated into the comprehensive permit if the board decides to grant the same, and attend at least 2 evening meetings of the board. So those were the minimum requirements the firms were supposed to respond to.
Ms. Clark?
And we had two firms submit proposals, the CEI, and it was Beals and Thomas. And there were, I believe through email, you had said that one or two of the other firms felt that they were not experienced enough.
That's correct. Fuss and O'Neill sent me an email saying that they thought they would be unresponsive, so they decided not to submit.
And Ms. Barry, if I could just ask you for a second, could you, Marlene gave us a rundown of what the peer review's minimal requirement would entail. Can you just give a quick overall summary of what the role the peer review will have with this board?
Sure. The peer reviewer's job is to make sure that the board has the information that you need to make a decision, and that the board has the same access to the same expertise that the applicant has in terms of interpreting and understanding the plan, to help the board frame questions perhaps that the board should ask. If it's not obvious to you, then just sort of basically coach you. And also to try to then work perhaps with the applicant to address some of the issues that are identified in the peer review report. So they'll review their plans, they'll review their whole submission, they'll come to you and say, here's what looks fine, here are things we think that need to be addressed. Perhaps there are some things that the applicant hasn't done that the peer reviewer thinks should be. So you get expert advice. That's from someone who's qualified to review an engineering plan. I'm not an engineer, I'm a planner. So, I don't play that role, but that's what it is.
Thank you. And I think what everyone else should also know is that the applicant pays for the peer review. This does not come out of town funds, it doesn't come out of taxpayer money. They pay for us to have the information that we need, the expert information that we need. Steve Maynard and I and Judy and Marlene sat for a good 35, 40 minutes going over the two proposals. This is certainly one, part of the record now if anybody wants to see it. And we were very comfortable choosing CEI for their experts in the field. They had a great many engineers and experience with 40Bs, particularly with the wastewater, which is something I think the town of Carver will be especially concerned with in this situation. So we were very happy we were chosen. We chose this one. And Stephen?
Yeah, I thought there were a number of both firms were really qualified, and it just came down to more of a cohesiveness on one particular team, in this case CEI over Beals and Thomas, which I thought was just helps in the overall process, and plus their ability to work with the North Carver Water District. If this goes forward and plugs into that system, that kind of cohesiveness is a benefit to the town. So I think I thought it was an excellent decision.
Are there any questions concerning that?
How many requests for bids were sent out?
6 were sent out, and Marlene read the names of the firms that were sent out. And we received 2 in hand and an email from one that said they would not be participating. And there was no answer from the other 3.
Yeah, that's not uncommon, by the way, just so you know.
And Judy said that that's...
Yeah.
Any other questions or comments for the vice chair?
No, we asked the same question when we sat in the meeting, was it common or uncommon to get responses
we
back?
did. We did. so.
Mr. Chair?
Yes.
If I may, I would have a question and a comment.
Before you get into that, if you'll just indulge me for a second.
Certainly.
So that everyone understands this process, the developers team has no role in selecting our peer reviewers unless we allow it. And in this case, they did not participate, nor did the attorney or any representative for the neighbors in opposition. So this was a process that was exclusive to the Zoning Board of Appeals, this selection process. Just so that everyone understands that there was no outside or extraneous influence from either side in the selection of this particular firm and the expertise which it offers. I also want to mention for the record that the selection of a peer reviewer or peer reviewers is solely within the jurisdiction of this board. The developer has no input, nor does any member in opposition have, I shouldn't say input, but they don't have any power to direct us one way or the other. I want to make that clear, especially to the development team. I also want to make it clear, as I think I just did, that there were 6 bids that were sent out. And we had responses from 2, and we vetted both of those, as you've heard from Ms. Clark, and vetted them carefully. If anybody would like to see the credentials of this firm that the board is about to decide on as its peer reviewer firm, we'd be happy to provide them. I think their particulars are in the file already. Is that right, Ms. McCollum? So if anybody would like to check for themselves to see whether these folks are qualified and whether we made a good decision, and I think that from the sound of it, Ms. Clark and Mr. Maynard did make a good decision, then you're more than welcome to look at the file and read through it. So I just want to make that clear for the record. Now, having said that, does anybody have any further comments or any points of discussion before we go to a vote on this? And I will hear from you folks in a second, but does anyone else have any further points that they'd like to make? All right, we're not going to go to a vote on this just yet, but I will entertain a motion
To accept them?
to accept the subcommittee's recommendation of this firm as its peer reviewer. This is going to be 2 peer reviewers, as I understand. Is that right? One who's going to be a professional engineer and one who's going to be a wetlands scientist?
Actually, it's a team.
It's all under the same.
All the same team?
Under the same team.
If I can clarify that
Yes,
for
please.
the board. So there are 2 PEs, professional engineers on the team, a professional wetland scientist, as well as an ecologist on your team.
And that's helpful, thank you. So the depth and breadth of this experience that is going to be afforded to your board, I believe will be impressive. Does anyone else have any questions or comments? If-
I think I might also add that we're not bound to accept the lowest bid, and Beals and Thomas was the lower bid, but we're not bound to have to accept the lower bid because this isn't, a town project or a town-funded project. And the bid can go up, or it can go down. I mean, the amount of money that they have to deposit with the town for us to draw down upon. But everything exceeding the scope of the original proposal, if we need more, we get more. So we're not completely bound by just what is printed. If we feel we need something else, we get something else.
To put it another way, this is a qualifications-based procurement. So again, whoever we think is best qualified to address the technical issues relating to this project, that's who we go with. Everybody good on that? Everybody clear on that? Any other questions or comments from the board?
The only other comment I had was one of the questions I had asked in the review was the disparity between the bids. And when we looked at it further, Beals and Thomas was under the assumption that the delineation of the wetlands had already occurred, so that was not included in their bid, but it was included in the bid by CEI. My feeling was that the general numbers for Beals and Thomas would have gone up fairly substantially and probably been a lot closer, if not over, CEI, which was also one of the factors we decided on.
Thank you for that. That's important information. Any other questions or comments from members of the board?
Good.
Do I hear a motion?
I'd like to make a motion to accept CEI as the peer review engineer for this project.
Do I hear a second?
I'll second.
Now, would you like to be heard?
I have something informational, if I may. Thank you. The plans that we have prepared are based on the supporting documents required under the board's application for the comprehensive permit. They're also based on the standards that are set forth under the subdivision control law. Under either case, there's no requirement for a stormwater report or a drainage analysis to be peer-reviewed. At this point, that's something that's generally handled once we're done with the Board of Appeals and we find ourselves in front of the Planning Board with a definitive plan. And at that time, the TR 55 calculations are done for the drainage report and the stormwater runoff. The drainage that you see on these plans has been calculated using the rational method. It's easy, it's quick, there's charts, there's graphs, and you figure out your time of concentration and you do it, which is appropriate for this type of application where we're examining feasibility. Is this thing really going to work? And that's the intent of these plans, although in my not so humble opinion, I hope you find them very well done. And I think out of the information, perhaps with all due respect, I might suggest that the amount of front money that Mr. Draper puts in the bank for you people to draw from might take into consideration that at some point this is going to the planning board and they will be using some of that peer review money. So perhaps it would be appropriate to spread the load around. But I'm just letting you know that I hear in what you call an RSQ, a requirement to review stormwater runoff calculations.
Okay.
When there's no requirement to provide those.
Which wants to go first? Ms. McCollum.
I'd like to remind the board that this is a comprehensive permit. There will be no review by any other local body. The planning board will not see a definitive plan for this subdivision. You are responsible for reviewing these plans under the subdivision rules and regulations that are not asked to be waived. You are playing the role of the planning board.
In addition, Mr. Chair, this is exactly why you need a peer review consultant with a lot of experience with Chapter 40B, because the peer review consultant will be able to look at the applicant's submission and advise you that it either is consistent with what is normally provided for a subdivision under Chapter 40B or it's deficient. So rather than you having to worry about whether the applicant's right or wrong, the peer review consultant will help you figure that out.
Well, I wanted to give Mr. Parker his say.
Sure.
Thank you.
He must have been looking down or reading or taking some notes when I made my opening remarks. With comprehensive permits, the buck stops locally with us. You're dealing with us.
Mr. Chairman, may I have a moment just to ask a couple of questions? And I appreciate the fact that your position that...
On the issue of the...
Peer review.
Peer review.
Yeah, I'm not going to argue about what your role is. My questions are several. I mean, I heard the list of the 6. I didn't hear a couple of engineering firms that are well-known in the 40B field, like Niche Engineering, which has done many of them in southeastern Massachusetts. I'm curious about that. I'd like to know what the cost was for Beals. And I'd like to know what fees the town has assessed in projects of this size and nature in non-affordable settings. I appreciate that your decision is final here, but it's subject to the regs and reasonableness and a number of cases out of the HAC as to what's reasonable for a consultant fee. Because as you well know, imposing economic burdens and hurdles that are unreasonable, and I'm not suggesting this, but is disallowed. There's a case, White Barn Lane v. Norwell ZBA number 2008-05, a July 2011 case that speaks about the reasonableness of peer review fees. and it judges it in light of and compared to fees that are imposed for non-affordable housing projects. When we saw the $17,000, I must tell you, we were a little taken back, because it's a project with 30-some, it's not hundreds of units, it's not a massive development. Our concern is that, of course, we don't want to be priced out of being able to pursue this permit. And
If I could just interrupt for a second, and I think all your points are well taken, and I understand completely the argument that you're making, that, you know, you don't want to set fees so high as to, in essence, prevent a developer from moving forward because you're setting conditions which are uneconomic.
well, that's the cases, and
I
that's
think
how the
that's your
courts have.
argument. However, one important piece that you left out, in my view, and I'm going to turn this over to Ms. Barrett in a minute, who's leaning forward and seems like she wants to shout into the
Being very
microphone at
patient.
me,
No, I'm being very patient.
is that there are highly technical issues with regard to water, in this case, that are particular and peculiar to the town of Carver. And so this is why we were insistent as a board when we last met that not only the typical engineering, civil engineering peer review take place, but also that we get a wetland scientist with an expertise in water and flow to help us out with this. Now, Ms. Barrett?
If I may, Mr. Chairman?
Yeah.
I appreciate that argument, and I presume that that argument would be made in every subdivision proposed in this town. Correct?
I'm not sure.
Because water, I mean, you.
I'm really only concerned about this one right now,
No,
Mr.
but
Kraus.
you're, Mr. Chairman, the law or the findings of the HAC speak in terms of comparison to projects of a similar nature size that don't have an affordable component, that are not a 40B project. And that my concern, and the question to the board, not by being argumentative at all, Mr. Chairman, is trying to determine what, if any, fees you've imposed on non-affordable projects of a 30-some unit subdivision, because it appears that this water issue is prominent throughout the community.
Mr. Chair,
Yes.
I suspect that the Board of Appeals hasn't imposed a review fee on any comparable project without affordable units, because the board doesn't have jurisdiction over subdivision control unless the project includes affordable housing and is filed under Chapter 40B.
Well, Ms. Barrett, I'm only
Excuse me.
talking about any
I'm going
project
to
in the town.
finish.
Well, let her finish, Mr. Kraus. Go ahead, Ms. Barrett.
Just to be clear, if the applicant is aggrieved by the board's decision, the applicant can appeal administratively to the Board of Selectmen within 20 days of the board's decision. The basis for the applicant's appeal is limited to two factors.
Like conflict of interest and.
One is whether the applicant believes that the selected consultant has a conflict of interest, and the other is whether the applicant challenges the qualifications of the consultant. Neither Chapter 44, Section 53G, nor the Chapter 40B regulations specifically provide for an appeal based on the fee. The issue is whether the scope of work that's described in that RFQ addresses what the board needs. And I think one of the differences in reviewing a Chapter 40B application from some other applications is that the board has to make a decision based on a preliminary plan that includes some unknowns, and has to be able to write a decision with conditions that address things that you can't see today. So although it is certainly true that the board has to be careful not to treat a Chapter 40B application differently from some other application, the fact is that your application is different, because it was not filed as a subdivision to the planning board under subdivision control.
Mr. Chairman, I appreciate Ms. Barrett's position, and I'll read from the case.
I'm very familiar with the case. This is irrelevant.
It's 37 pages. If you don't have it memorized, I'll help you with it.
It's not really
Please,
not
wait,
germane.
both of you. I think this issue has been well identified. From your standpoint, you think the peer review fee is excessive. From Ms. Barrett's, she disagrees with you most respectfully. You've heard from Member Maynard, who gave an explanation as to why one peer reviewer quote was lower than the other, and that certainly made sense to me. I think that we have discussed this long enough. You have to decide whether you will go ahead and pay this money or not.
What was the amount of the other bid, if you may?
I actually don't have it with me.
Beals and Thomas, with assuming that the wetlands have an order of delineation, was $11,000.
And that's assuming the delineation, correct?
Yes.
That was assuming, correct. That was
So
my,
it's
that was
six-
my first question, was why the difference?
The wetlands, Mr. Parker's telling me that the wetlands have been delineated, so someone would be reviewing our flags. Is there, again, I know this is the first 40B that the town has undertaken, but the case speaks to what the town, whether the planning board, the Board of Health, whatever it is, has charged to review, not just the ZBA, but comparable peer review expenses. Page 33 of the decision. So Beals and Thomas was $6,000 less than this, the one that you want to choose.
And you've heard one significant reason why we think it was less.
But we don't know, Mr. Chairman, do we? We
Actually,
don't know.
Yes, we do. Yeah, it was clear. It was clear, it was noted in the,
Ms. McCollum, you have something you want to say?
I do. As to comparables for the town of Carver, there have been no recent subdivisions of this size for me to give you any comparable data. The largest, most recent subdivision that the planning board did was 6 lots. That's not a comparable subdivision.
Copper Lantern.
Now, I can tell you that the rates, the hourly rates for CEI's team are lower than Beals and Thomas. You will get more for the money. I can also tell you CEI's rates are lower than the hourly rates for the planning board's peer review contract with Fuss and O'Neill. So comparing the rates for your team, they are affordable.
And if I remember, Beals and Thomas were including 1 meeting, and CEI was including 2. They were both including 2?
Yeah, that was the minimum.
Oh, okay,
That's what the scope said.
okay.
So I would ask, Mr. Chairman, and I appreciate the planner providing the information. So for instance, like Copper Lantern is a subdivision of a decent size in the community. And I wondered if you had any information about that one.
Copper Lantern Lane, I don't believe was permitted as a subdivision. I believe it was permitted as a special permit townhouse development.
Do you know how many units it was?
It's not a subdivision. They're not comparable.
Yeah, just humor me. Do you know how many units it was?
No.
I think it's about 40, maybe.
Yeah, I don't know offhand.
I think there's 5 or 6 buildings with 5 units in each. I'm not entirely certain, but it is a townhouse development. There's 5 buildings. And I might add, Attorney Kraus, when they're doing a subdivision review, they're following our subdivision,
Understood.
but our minimum lot size is 60,000 square feet with 150 feet of frontage. You're considerably smaller, so I don't see how a subdivision review, peer review is anywhere near the same as this.
Well, if you look at the density, if we're just talking density, Mrs. Clark, for just a second, between the 40-unit condo or whatever it was, what is it? 42 units,
Those were 2 bedrooms, you have 3.
okay? I'd only like to know what was charged them for review. I'm trying to.
Mr. Chairman, I believe this discussion has run its course.
Anybody have any questions or comments up here? Mr. Glick has waited patiently. I will hear from him briefly on this point.
No need, the vice chair just made the same point I was going to make. Thank you.
So I have a motion and a second, which has been made on the issue of accepting CEI as the peer review team to assist the board on this 40B project.
And to clarify, that will be $17,000.
And to
As-
clarify,
as
this will be
written.
$17,000.
It's as written.
Are we ready to go to a vote?
Sam?
All in favor?
Aye.
Aye.
Now, before we get into hearing from the petitioner about the specific project, I have a pointed question to ask. When can we expect payment of the peer reviewer's fee? Or do you need to take a timeout on this?
No, you can set a reasonable deadline, but I'd like to have a chance to talk to my client about this based upon the scope of that and have an opportunity to respond to you in a thoughtful way. I mean, we understand that without the payment and the peer review, it's not going to go forward.
Would you like a brief suspension of these proceedings?
No, I'm going to suggest to you that if you give us 30 days to make the payment.
And this would be payment in full?
Of course.
Ms. McCollum? I'm sorry. If, I assume CEI cannot begin their peer review for 30 days if the payment is not received until then. Either you or Ms. Barrett, how does that affect our timetable? Does it not? Should we have the peer review information, at least the first wave of it, before then, or is that reasonable in our 180-day timetable?
So the town cannot enter into a contract with CEI until the funds are in hand. So we cannot authorize them to proceed with any work on your behalf until that contract is signed. So that would mean that if the funds are received in 30 days, the contracts could be signed, a notice to proceed could be given then. They would obviously need some reasonable time to do their work in order to give you a report in time, for your hearing.
And Ms. Barrett, in your experience, is that a reasonable amount of time? Okay.
And also, Ms. Barrett, a question from me, and it is this. Once our peer reviewers get this case, in your experience, how long does it normally take before we get some input?
Couple of weeks. I mean, if they're busy,
I didn't hear that.
I'm sorry, usually like a couple of weeks. I mean, you'll find out early on if there's missing information, but typically, if you've said to your peer review consultants tonight, we need you here in a month, if there was no dispute going on about the fee or anything, then the peer reviewers would be here. They may not have the whole report done, but they would certainly know, I've got a deadline to be able to tell this board there are big issues or not, or here's what's missing.
Do I hear a motion from any board member to require the peer reviewer's fee to be paid in full within 30 days of this evening?
I'll make a motion.
Do I hear a second?
I'll second.
Do we have any need for further discussion on this?
No.
So it would be 30 days from this evening for receipt in full of the peer reviewer's fees so that we can get them involved in this case. Mr. Glick, quickly.
If I may make a suggestion, it seems to me the simple thing to do here is to, if Mr. Kraus and his team need an additional 30 days to come up with the money to pay for the peer review contract and get them started, then the back end should slip as well. And so that means that the 180 days doesn't end on, I think it was January 15, 17, it would be February 15.
Well, let's possibly take that up in the next motion. We'll do this motion first. We have a motion and a second. This motion, again, is for the peer reviewer's fee to be paid by the developer in full, not later than 30 days from this evening. All in favor?
Aye.
Mr. Kraus, what's your thought about pushing the 180-day clock off?
I think it's premature tonight to do that. I think that if more time is necessary, we're going to cooperate.
Okay.
Because, we'll be close to the end or close to the beginning of something else.
Does anybody want to discuss the issue of,
Ms. Barrett, what's your thought on that?
I'm sorry, I was reading a decision. What was your question?
As far as Attorney Glick's suggestion that if we wait 30 days to even begin our peer review, can we extend the 30 days on the back end? Do you think that's even necessary, or in your experience, is that something that, I mean, this appears to be fraught with delays here, and
Yeah, I know. I mean, I think that if the applicant needs additional time to come up with the money for the peer review, which, you know, certainly people can respect, then, I mean, if I were the board, I would be asking to cover that extension now, just so that you're not arguing later about it. It's just much easier to do it up front than to do it later.
so you're suggesting that perhaps the board
I would say.
incorporate the idea that if you miss the 30 days, we automatically start extending?
That would probably be a good way to do it. If, you know, give them 30 days, and if they come up with the money in 30 days, and you can get the peer review going, then you don't need to talk about an extension yet. You may still need to talk about one later, but you don't need to do that now. If the applicant needs more time beyond the 30 days, then the applicant should agree automatically to give you an extension. And that way you won't be arguing about it.
But these things typically take care of themselves, because we'll see where we are come, depending upon what the peer review engineer says. Because depending upon the comments, it may entail excessively additional time.
Yeah, it would be
or
to your
not.
advantage to agree.
Yeah, we're not going to, it's not to our advantage to bring you to a vote that has not given us a full and fair opportunity to present our case.
Any other questions or comments from members of the board? A very brief comment from Mr. Glick, please.
I think what we've seen here is that there is a pattern already established of incomplete submissions, so that we're looking at a longer time frame to evaluate things as it is. And on top of that, there's another concern here. There's a third party here. That's the public. And some of my clients may want to undertake their own review. And that's going to be dependent on looking at what the peer reviewers say, looking at what eventually the applicant submits. So I would suggest to you that now is the time, if they're not even going to get the clock rolling on the peer review for another 30 days, then by all means, the back end needs to be accommodated as well.
Well, I would say two things, and this is just for me. One, I think Mr. Kraus, who I know from previous experience, is an upstanding member of the bar, and if he represents something publicly to this chairman and the rest of this board's members, I'm inclined to believe that his promises are credible and that he will follow through.
Thank you, Mr. Chairman.
Secondly, the petitioner is not saying that he's going to need the full 30 days. This check could be written presumably tomorrow. So, from my standpoint, I'm inclined not to take any action on extending the time period just yet. We'll see how this goes. And believe me, if it gets to a point where we feel we do not have enough information, and/or the developer believes that it needs more time, I believe, based on already past experience where they've agreed to extend, that they will continue to cooperate and do so going forward. So I think we're good. You know, maybe somebody else has a different opinion, but that's my own personal opinion on this issue. Ms. McCollum.
I would request that the board set a date of either August 11th or August 22nd that will help me accommodate receipt of this check, because the week of August 15th, I will not be in the office. And I do not want it misplaced.
All right, so that makes it 26 days? How many days?
Either the 11th of August or the 22nd of August.
Got it.
Is that okay?
Got it.
So we'll take a quick vote on that the check is to be received. I think we said before, within 30 days. Now
The
it's
22nd. August.
Say the
By the
22nd.
22nd?
Yeah,
By the
just
22nd.
make it-
So somebody want to put that in the form of a motion?
It's an easy way to do it.
I'm confused.
I'll make a motion that the check needs to be received by the town planner's office no later than the 22nd of August.
So we are rescinding our earlier 30-day vote?
And
Going to
making it
31.
31.
We're making it 31. Okay,
I'm not counting today.
Okay.
right.
Justice grinds slowly.
We have a second on that?
I'll second.
All right, so this is, in essence, by its terms, a rescission of our earlier vote for 30 days, and we're making this 31, right? 31 days. All in favor?
Aye.
Okay.
Mr. Chairman, may Mr. Parker, our engineer, actually present the plans that he prepared for you so that the public can actually see what we're talking about?
Yes, we're gonna do that in a minute. We have all these other issues that we needed to discuss, and we're almost at the end of the list.
Okay, thank you, Mr. Chairman.
Just one other thing, actually, on my list, and that is the town planner's memo, which I referenced in my opening remarks, dated April 7, 2016, identified, by my count, approximately 7 specific areas where the petitioner's plan, as originally filed, was deficient informationally. Now, I know that, or I suspect that both the planner and Ms. Barrett have looked at that plan, the new plan, the so-called new plan, the one that came in a day late. And before we get into the actual presentation, I want to make sure that each of you is comfortable with saying to us that the revised plan addresses the informational deficiencies that we identified back in April. Ms. Barrett, why don't you go first?
Since and I'm not playing games with you, but since I'm not an engineer, I would look at a plan, and I'm not going to pass judgment on whether it's a complete plan for the submission of this board. I just won't do it. That's why I'm so concerned about you getting a peer review consultant.
And Ms. McCall?
It does address a number of things, and it is based on an on-the-ground survey. It does include topography, current wetlands delineation, distances and bearings, and locations of existing structures and wells on abutting properties. So that information is received on a plan stamped both by a PE and a PLS. So that is, I would say that that is reliable. However, there are a number of items that are still outstanding based on my memo. And
Could you identify for the board what those are?
we do need a stormwater report based on the subdivision rules and regulations, since you are sitting as the planning board. We do need to know if there is any import or export of earth for grading. We do need to know information on traffic. We need an update on the Natural Heritage and Endangered Species Program filing. I do need to know the type of IA septic systems that are proposed for nitrogen reduction. We do need information on the lottery plan and methodology. On Tuesday, I did receive a list of waivers. However, there are no waivers here for local Board of Health or wetlands rules and regulations. And I would like to confirm that this does include waivers from subdivision rules and regulations. So I do need more information on the waivers, just to make sure that this is what they want to submit. And I do want to say that the zoning waivers, which I have reviewed, I do think that the information here is accurate as to what is required. However, This is telling me that that these waivers are based on the zoning bylaw amended March 2013, and that is not the most recent version of the zoning bylaw. I have not had time to sit down and double-check all of these extensively, but I did notice the date discrepancy right away. I do think that the most current bylaw is online. So those items are still not part of the board's record.
So I'm going to ask you, on behalf of the board, Ms. McCollum, to find a few moments in your busy schedule to draft us a memo, basically giving us in writing what you have just reported verbally. And when you prepare such a memo, I would ask at the same time that you provide a copy to Attorney Kraus and also to Attorney Glick. Because we're giving you 31 days on the payment of the peer reviewer, you've got some lead time here to satisfy these gaps that Ms. McCollum believes she has identified. So to the extent that you can use this additional time that's been given to you for payment purposes to fill some of these gaps, I think it would be to your advantage, because the peer reviewer, when he gets this case, or she gets this case, that team, is probably going to want these gaps filled anyway. So better to get ahead of the curve. Okay? So, Ms. McCollum, if you could sometime, perhaps in the next week, prepare something along the lines of what you just told us, and get copies to Attorney Kraus and Attorney Glick. Is that okay?
Yes.
Thank you for that information. So we are, at long last, ready to begin to hear from the petitioner. And I do want to say tonight, it's 8:20, so I anticipate that we will hear from the petitioner, they will present this plan, and then we will take a timeout, because our peer reviewers will then have to take a look at this and present their oral and written report to us at our next meeting. So we're not going to be taking public comment tonight. We're not going to be cross-examining the petitioner tonight. This is going to be for informational purposes only. This is their opportunity to present, and then we will go to our next meeting, at which point we'll hear from the peer reviewers. We'll hear after that from members of the public. And I assure you, as I did back in April, that I will recognize anybody who wishes to speak, so long as the comments are not repetitive or defamatory. So each and everybody will have their turn, but tonight it's the petitioner's turn. So I turn the floor over to whoever wishes to speak for the petitioner's team at this time. Mr. Glick rises. What is it, Mr. Glick?
I understand the hour's getting late, but I still don't, I'm having a hard time understanding exactly what the process is. It's not that I don't understand what you just said. You were very articulate in laying out the process. I just don't understand how it fits within the 40B process here. I mean, what we just heard is, and what we all know, is that this application is nowhere near complete.
If it's not complete, and if there are information gaps, as Ms. McCollum seems to believe there are, and perhaps our peer reviewers too, they will address it, and they will talk to us about it the next time. But for now, we're going to give the petitioner an opportunity to speak. And if there are gaps that remain at our next meeting, and the peer reviewers identify these, then, you know, that's something they're going to have to live with. For now, they're going to address the board, and they're going to talk to us about this plan.
So this is, in a sense, almost an advisory.
This is an introduction for us as a board and members of the public to hear what this is all about.
If I may, though, there are items that that we would add to Ms. McCollum's list, some of which I think are extremely important, and I didn't hear. For instance,
Can you give us that list in the next 30 seconds?
Well, Mr. Chairman,
I'll speak very fast, yes.
Because, you know, if there are concerns, then I would think that you would want to identify these and make a judgment as to whether they are valid or not. So let's hear what you have to say with regard to these information gaps that you feel Ms. McCollum did not identify a few minutes ago.
Well, I'm not criticizing Mr. McCollum. I just said, I think that there's also some things that are still missing. For instance, and you did mention the Board of Health regulations, the very strict requirements of the town of Carver concerning Board of Health issues, like the 150-foot radius as opposed to the 100-foot radius from wells, is not there. In fact, one private drinking water well is just completely left off the plan. It just says, we don't know where it is, so we're not showing it on the plan. That is completely unfair and completely lacking. The fact that they're using the 2013 bylaw, as Ms. McCollum said, is borderline. It just speaks volumes about what we're dealing with here. We're also there's, as she said, no information about the septic systems. The stormwater report is very key, and the current wetlands delineations. We understand, it's our understanding that there are issues with the wetlands delineations, and that will have to be examined. So that these are not, these are the developer's wetlands delineations. I don't think we can take those as gospel at this point. But primarily, it's the aquifer protection issues that need to be addressed and need to be addressed as part of the application.
So, Mr. Glick, I have a suggestion for you, and that is,
I thought you would.
based on the concerns that you raised on behalf of the neighbors in opposition, I would ask that you send a memo to Ms. McCollum, copy to Attorney Kraus. Ms. McCollum will get us that memo. It will become part of the file, and she will incorporate it to the extent that she feels in her role as town planner. She'll incorporate these suggestions and concerns of yours in an email or communications that she will be having going forward, as will Ms. Barrett with our peer reviewers. So all of these subjects will be covered. This is going to be a comprehensive review by our reviewers, and we intend to make sure that we leave no stone unturned in terms of getting all the information that we need so that we can make that intelligent and careful analysis of the facts and how those facts apply to the law.
And Mr. Chair, thank you. I will do that. In my haste, I did not mention one thing, and that is that the waivers themselves are woefully lacking in backup and understanding. I mean, when you say you're seeking a waiver about tree cutting, and the response is, we need a waiver because it's a forest and we're going to be able to cut. We need to be able to cut down.
Well, before you go any further with this, I mean, I don't want this to get into a ping-pong match here, because Mr. Kraus is getting antsy, and I'm going to feel compelled to recognize him in a minute. I would ask that you please enumerate these concerns in an email. Just go 1 through 3 or 6 or 10, get them to the planner and Ms. Barrett. They in turn will get them to our peer reviewers and the rest of the members of the board. So to the extent that any of these concerns of yours are meritorious, and I'm not making a judgment one way or the other, but to the extent that they are meritorious, they will be properly peer reviewed.
Right.
Now, having said that,
Can I say one thing, Mr. Chairman?
really quickly, because I'd like to give your team the opportunity to
Yeah, I'm going to be
present.
very brief. The 40B process is a process. It's dynamic. The waivers will expand, they'll contract, they'll change. The lottery is something that's done by agreement with housing, with Mass Housing, you know, picking a lottery agent and a monitoring agent. These are form documents. There's nothing to it. It's important. We can find fault, as council does, with every single point, but I think it's important for the board not to get lost in the trees from the forest. That is, to focus on what's primarily important to the town of Carver, as you indicated at the outset, because you're supposed to, through your board, and I know you are, is protecting the vital interests of the community while at the same time being fair to us. as an applicant
And following the law.
and following the law. That's why I made the point with respect to the peer review and consultant fees. That's why I'll continue to bring to your attention cases from the HAC and the courts. And again, the points that were raised and what counsel indicated. Again, as I think Ms. Barrett may agree with me, we'll find some point of agreement during the course of this. Things change. It's dynamic. This is a dialogue. We'll make changes based on your requests. Hopefully, you'll agree with some of the things we said. It's not final tonight. What you see on this plan, I will bet you, will not be the ultimate whatever you vote on. So the idea is the board should keep in mind that things will change and that we will cooperate. And
Thank you,
we will
Mr. Kraus.
work with you.
Thank you.
Randy, please.
I observed a moment ago that Ms. Barrett had her hands over her mouth like this, so we're going to move on now.
I think it's a good
And
idea.
I understand, Mr. Parker, will you be the designated presenter of this plan for the development team?
For the time being, that appears to be the case, Mr.
All right,
Gray.
so your bona fides, please. What is your professional background?
I am registered in the engineering disciplines as a registered professional land surveyor. I have worked for the Department of Public Works, the Division of Engineering in the state of Illinois.
As a land surveyor?
Well, for the state of Illinois, I had done materials testing.
But are you a professional engineer? Do you have a PE?
No, sir, I'm a professional land surveyor.
Okay.
Our professional engineer is Carl Anderson. He's both civil and structural.
But tonight you present as a professional surveyor on behalf of the development team.
Yes, sir.
Proceed.
Thank you. Before I get started, I'd like to say that the waivers were based on a request for zoning and subdivision control. When we get a punch list from Ms. McCollum and from Mr. Glick to address health and wetlands differences, we'll be happy to do that. One thing that I noticed when going through the subdivision control law is that there is a requirement for an ANRAD, an abbreviated notice of resource area determination, that affects the location of the wetlands flags. So we've had Brad Holmes of ECR LLC. He does a lot of work in the region. He's a certified environmental scientist. I hope well-respected. Everybody that I know thinks highly of him. But regardless, there does need to be, if we are to follow the process, and no waiver was requested for the ANRAD. We would expect need to do that. That being said, whatever people want from us as we go forward with my client's assent, we will gladly do. We're accustomed to peer reviews. We're accustomed to departmental reviews. The fire chief may look at this and say, I want fire hydrants every 500 foot. I want to blow off on this location. We want to loop the water. And as we take these preliminary plans and craft them into something definitive, that, as I think Mr. Kraus said, becomes a cooperative effort. So we have 12 sheets of preliminary plans.
Can I interrupt you for a second? Is it going to be on, Marlene, is it going to be on the screen? Is it on that computer?
Just tell me what plan sheet you want
Yeah,
up.
well, let's start with sheet 1.
Yeah.
And I will try to be brief.
That's appreciated. Thank you.
Well, I'm not famous for brevity, Mr. Chair.
Do you want me to turn on the lights, Mr. Chair, so that people can see? Can they,
Let's see how it comes up first.
That's a pretty good screen.
There we go.
Everybody see that okay?
Yeah.
can you see it in the back?
He's not going to be able to.
If you look at the
inflate
next
beyond that.
page, it'll probably be
Yeah,
bigger, because this is just
Yeah,
the,
well, I tell you what.
that sheet is just the introductory sheet.
Yeah, it's just the cover sheet that shows where in the world we are.
Yeah.
Sheet 2's existing conditions. I think we can skip that. I'd simply say that,
Which sheet do you want Ms. McCollum to put up?
all right, let's go to, talk about being brief. Why don't we go to sheet 4 for just a minute? You know what, Marlene? Let's get to the utilities grading and layout. That's where all the meat is.
What sheet is that?
Sheet 7. Let's go to sheet 7. We're over half done.
Okay.
All right, Mr. Parker, proceed.
Thank you. Can you hear me all right with the microphone that
I can
far
hear you
away?
fine, go ahead.
So as you can see, we have an entry off of Plymouth Street. We have, when we get further along, and I don't think we need to spend much time on profile sheets, a 9% grade coming down from Plymouth Street to the low point. Contrary to the original plan that we envisioned, where we had only 10-foot contours available to us, shooting the on-the-ground topography, there's a natural drainage area that develops as you're looking at that screen.
Do you want me to go up there and point to it? Is that, because do you have a laser? Anybody? Do you have a laser, anybody?
Oh, my cat has mine.
So show me where you want me to point the attention to, right here?
See where it says drainage, Rob?
Right there, yeah.
Okay?
Yeah, we had a completely split entry to begin with, but when we did the on-the-ground topography, we saw a hole to develop there that was a perfect place to put the drainage at the low point, coming off of Plymouth Street and then rising again to the bulk of the property, which is right around elevation 130 to 120.
And Plymouth Street's at the very top,
Plymouth
correct?
Street is at the top, correct.
Okay.
The petitioner has chosen to name this Tall Pines. We split the road at approximately station 4+00. As you go left around the screen, the stationing grows. I was really very pleased with the job that our CAD people and the engineer did on the lotting. The lots run about, on an average, a quarter acre, 10,000 square feet apiece. And he was able to go around and get the 39 lot or unit count without creating any back lots or unusual configurations. It's been kept, I think, simple. The grades are all reasonable. We also have a little bit of drainage. If you, there you go. In the location between the road looping back towards itself. The other grades, if we could go to sheet 8, Ms. McCollum?
And Randy, why don't you just generally explain so everyone watching this on TV or here, how many lots are there in this plan?
There are 39 lots on this plan. And
How much land is there? Can you go through it?
we've got 17.35 acres by calculation, which is somewhat less than the assessors
Okay.
give us, but the perimeter has been calculated in from record plans and field location, so we think that that's accurate.
And the whole it looks like a bow tie, correct? Do we have a sheet that would show the entire development on,
That would be the cover sheet.
okay?
If you
Can
want
we
to
go
go back
to-
to sheet 1.
Marlene, can we just go to the cover sheet real quick, just so, and we can magnify that so people get an idea of what the whole perspective is? This,
Yeah.
if we could magnify that, right there on the left-hand side. Okay.
Very good,
Okay, so Randy, can you do that again for us? You see Plymouth Street at the top?
right?
I'm not oriented north, south, east, or west, oh, there it is,
It's
north.
north, yeah.
So it is due
Due
north.
north.
Correct. We always do north up the page if we can, or to the side. So we're starting at Plymouth Street. We come in 400 feet, the road splits. The stationing progresses counterclockwise. We have 3 or 4 drainage areas. We don't go into any wetlands with any of the road or drainage construction. Our steepest grade is the 9%, which conforms to subdivision control. The, let's see, if you look at that cover sheet, I think you'll see that what we tried to do was provide open space and distance between what was going on, where houses were being placed, to be located as far away as we could from the occupation around us. So I guess that's what it looks like in the overview. We talked about sheet 7. Excuse me. Sheet 8. On that cover sheet, we come down. Let's go to sheet 8 would be good. Thank you. So our grades proceed very reasonably down. There's a drainage area, as you can see on the bottom right-hand corner. We come around headed towards Arrowhead Lane. We have an open space by a lot 9-3, 9-4, and then on sheet 9, sheet 9 brings us back around to near the juncture of heading for Plymouth Street, and each of these sheets that we have looked at, 7, 8, and 9, tend to show the placement of the houses, in many instances, the septic systems that are proposed. Certainly, we've got
Randy.
down water here, yes.
Can you explain what this page is with this graph and these lines and what it means?
Sure. So when you get to page 9, that's our first profile page.
And what is a profile page?
All right, so if you look at what you see on the top part, you can't see the entire plan. You see the plan view of what is going on at 1 inch equals 40 feet. That's the scale that the subdivision rules and regulations look for. On the bottom portion of the page, you see what looks like a graph.
Yep.
And that is, in fact, at the left is the entry to the subdivision. You see a vertical curve. It comes down at 9%. It's another vertical curve with a sag point. And then you can see the slope coming up again to the property interior at in the range of 8% or so. Then all the grades flatten out. So in this first one, what you're looking at in profile is the road. And what we've tried to do is to hug the topography and to work with the land in terms of its slope and occupation, and to try and be as considerate as we could be. Probably never considerate enough in some person's opinions in citing what it is that we want to do relative to any structures. So that's the entry. We could go to page sheet 9 and sheet 10.
And Randy, can I ask you this? Based on this graph and the nature of what you testified to about it hugging the contours, is there a lot of material coming out?
No, and that was an interesting thing about importing or exporting any material. Everything stays on site. So we have, at this time, no expectation of doing anything but balancing the cuts and fills. We tend to leave about 10% more in fill than cut because you get some fluff out of it. And it becomes needed. So
So just to be clear, we're not taking material out of this. We're not doing this development to take material out.
it's not a soil extraction based on these plans. So sheet 10 is you're very good with that. That touchscreen that you're using the pad?
Yeah. It's a computer, Randy.
Well, I know what a computer is. I'm not good with touchpads. I need a mouse.
All right, let's keep going.
I like the mouse. All right, sheet 10, some of the stuff that's shown also on the profile, the center line, the left sideline, the right sideline, and then you can see the road that cuts through. It looks kind of magenta on the television screen. It's broad, and as you can see, it's quite smooth. We go from a high point to the left, low point in the middle, and then we start to rise again, going towards the easterly end of the bow tie and heading towards the other loop. So I guess we can go to 11. So this is more of the same. Again, it's plan and profile. We're coming gradually back up to the high point of the property, about elevation 130 or so. It doesn't show up very well on the screen. You can see in every case the houses laid out. In some cases, the septic. I'm sure, yes. I'm sure as we go along, and Mr. Pinkham has a chance to look at this, I would expect a request, as was on the first plan, to show that the septic does in fact fit on the lot. And we did not encounter any problem with that. As I said, we're dealing, for us, something that we're kind of accustomed to. And we see an awful lot of pre-existing non-conforming lots that give us 5,000 square feet to work with. And we still manage, as long as we've got a water supply, to get a house and a septic onto the lot. Here we've got 10,000 square feet, so it's plenty of room to work. Before I answer Rob's question about the wetlands, the last sheet, 12 of 12, these are this is simply the detail sheet taken from either the plates that are in Carver's subdivision control laws, and certainly a lot of this stuff we have stored in the computer. The road is entirely conforming to Carver's minor street specifications. It's 24 foot wide, the 1 foot Cape Cod berm, the grass strip, the 4 foot sidewalk. We're using individual lights at driveways. They could be solar powered, they could be wired to the individual home electric, depending upon, I guess, their preference and your preference. Get back to sheet 1, and I think that would be about it for me, except for the questions that you folks might have. Spare the microphone.
Good point.
Thank you.
Yeah.
We have, Rob's question was, where are the wetlands shown? Excuse me. The wetlands that ECR flagged are shown on sheet 2, and it is the existing conditions plan. site overview plan that gives us the topography, the adjacent structures, the adjacent roads. We have a cranberry bog to the west. I believe it's cultivated. The top of its bank still constitutes a wetland to us.
Right here?
Yes, and then there's a red line that is the 100-foot buffer.
Is this the red line right here, the dotted line? Can you see
Correct.
that on your plan?
Yeah.
And the subdivision, well, the development is in this parcel here. If you imagine, again, the bow tie, you'll see it, you can picture it using your mind's eye with the plan that we've developed. Go ahead, I'm sorry, Randy.
That's okay. I believe that bog is cultivated. The more significant wetland is all the way to the easterly corner, along with its, okay, so come straight up, and you'll see its 100-foot buffer that Mr. Holmes flagged in that corner. So
The blue dots,
they might look blue there, or I've got green, and I've got a red line around it.
are those flagged out there?
The flags are out there.
So when you go for your site walk, you'll see it, okay? So then they're numbered, aren't they, Randy?
Yes.
Okay. And the numbers obviously conform to the plans that you have.
And when the design of the subdivision was done, it was done without seeing a necessity for either infrastructure or home and site development to encroach on even the 100-foot buffer of the wetland. But I think regardless, you can't determine the accuracy of a buffer until you determine the accuracy of the flagging. So that's something that falls out of the ANRAD and conservation and their agent looking at it, and the peer reviewer too, if that provides the comfort.
And you know, Mr. Chairman, we obviously, under the law, have to appear before the CONSCOM, which is another safeguard for the community and an obligation on our part to pursue. So I thank you, Randy. Do you have anything else to add?
No, I would just entertain any questions that you might have of me.
Ms. Barrett, let's start with you. Do you have any questions of Mr.
Not at
Parker
this-
at this time?
Not at this time.
Ms. McCollum, do you?
No.
At this time? Board members, any questions at this time? Just
I do
by
not.
way of clarification more than anything else.
No questions at this time.
Ms. Miller?
The only question I have in looking at the map, when you do the profile,
What page are you, so we know where you are?
I'm finding one. Okay. So on page 9 of 12, and you've got the flat up top and you've got the profile down the bottom. The profile only corresponds to the piece of the flat that's up the top, correct?
That's correct. You can match the stations on the plan view. See station 37 plus 00.
It's right at the
Okay.
intersection.
Yep,
You see it?
Yep.
Okay, so that's the station coming back. So if you're looking at sheet 9, 0 plus 00 in the profile view, which I would point out is exaggerated to a scale of 10 times. Otherwise, this would look so flat to you that it would be hard to discern what the vertical differences are. So it's 1 inch equals 40 in a plan view, 1 inch equals 4 in the vertical aspect.
Right, so the road doesn't go, it's not a roller coaster. It gives you a sense that it's rolling, that it's not precipitous. And I think, what did you say, the highest grade is what, 9%?
The steepest is 9%, yes. So when you look at the plan view, you'll see 0 plus 00 out at the center line of Plymouth Street. And if you look at the profile, where you see 0 plus 00, that's looking through the ground, sideways, at the elevation of that plan location. So you can come down to, let's look at about station 3 plus 20 or so. you can see at Station 3, a little past, that low point developed.
Are you there? You see
Yeah.
that?
Yep.
Yeah, and so that's how the profiles and the plan work together. So any plan view that you see corresponds to the profile below it.
Thank you.
And it gives you a perspective of what the road looks like over a distance.
If I may, we've tried hard to comply with the regulations of the subdivision control law, so far as street width, sidewalk, slopes, 3-to-1 grading, such as that. The zoning waivers, that's a little different, you're comparing an acre and a half to a quarter of an acre. But we've tried to keep the roads, to the best of our knowledge, utilizing what we know as standards for minimum turning radiuses for fire apparatus and such. We've tried to keep them as close to compliance with the regulations as we could, and we've tried to keep them safe for the benefit of the public.
Ms. Mello, do you have anything further? Mr. Maynard, at this time, do you have any?
Not at this time.
Mr. Mueller?
I'm just curious on, I didn't see any detailed plans on any septic. I'm assuming it's going to be uniform across the board for each lot?
It will be.
Okay.
And as we progress, we can talk about the septic issues, pilot programs, INA, what's by right. It's another topic. I'll bring somebody with me for that.
Okay.
Anything further, Mr. Mueller?
Thank you.
Ms. Clark? At this time?
Not at this time.
Thank you, Ms. Clark.
You're welcome.
So if the development team has concluded its presentation for this evening, I note that we are close to 9 o'clock. As I said to everyone earlier, at our next meeting, and we'll set that date momentarily, presumably we will have our peer review reports and peer reviewers present, together with the estimable Ms. Barrett, who's a big help. And we will receive a report from all of those folks as to the technical particulars and any concerns which they might have. In the meantime, Ms. McCollum and Mr. Glick will prepare their respective memos, and those will be passed on to the peer reviewers in the interim, so that all concerns coming from the other side of the coin can be examined and addressed to the extent that the peer reviewers feel they need to be addressed. So are we all clear on where I like to take this going forward? Does anybody have any competing ideas or any other suggestions? No, good. So the next order of business would be to schedule our next hearing date.
Mr. Chair, I would like to, if you don't mind, I'll stay seated so I can have my material.
Is this a critique of what Mr. Parker just presented?
No, no, it's not. By no means is it. It has nothing to do with the presentation of plans. I'm troubled by what I've been hearing, and I think I want to bring it to the attention of the board. This is not a game. I mean, Mr. Kraus and Mr. Parker have said, well, you know, we're going to change things. This is all a dynamic process. It's not a dynamic process. This is not just throwing stuff against a wall and over a 6-month period we'll come to some understanding, I think was the term used.
Where do you want to go with this, Mr. Glick?
Yeah, because I'm going to stand up in a minute.
Where do you want to go with this?
Well, I want to go with the notion that I don't think it's fair to the town. I don't think it's fair to the board. And it's certainly not fair to my clients. We came here, for instance, tonight. We were given at the last minute as 4 pages of waivers that were requested. They were largely unintelligible, but some of them were very important.
And most respectfully, we've covered this already.
No, we haven't.
Yeah, we've covered the issue of the waivers, and the waivers came in late, and you didn't think that the information provided was adequate. So I think we've taken steps tonight to make sure that the voice of your clients is heard, and the voice of the peer reviewers is going to be heard. Ms. McCollum's voice will be heard. All of this stuff will be presented to the peer reviewers for the town, and we will get an informed report, both orally and in writing, the next time.
But the question is, an informed report on what? Because what we've seen here is,
I think that's up to the peer reviewers to decide. If they feel that there are gaps, wait a minute, if they feel that there's gaps in information, they will identify that for us. And if there are gaps and they feel they are significant immaterial gaps, then we as a board are going to compel the petitioner to address those. But right now, we're in a position where we don't have our peer reviewers lined up yet. We don't have them paid. So as a courtesy to the petitioners and also to the members of the public who have not seen these plans before, unless they've come in and looked at them in the file, I felt it was appropriate and fair to at least give them a few minutes tonight, and I don't think they abused that process.
they did not, and I don't have any problem with that. What I do have is the problem in this whole notion that we're just going to throw stuff up against the wall.
Mr. Chairman, I've never said that.
Wait,
I'm tired of being castigated
Mr. Kraus.
personally by Mr.
Mr.
Glick.
Kraus and Mr. Glick, I think we need to move on from this.
Fair enough.
Mr. Glick has made his concerns known for the record. I respect his argument, and I also respect the position that you're in, Mr. Kraus.
Thank you, Mr. Chairman.
We are basically done tonight. The only issue that we need to decide now as a board is when we're going to be meeting again.
Good.
And then we will continue this process the next time. Just be aware, everybody, that the peer reviewers will be given full and complete information to review. So if they have critiques and criticisms and concerns, rest assured we will hear about them.
Thank you,
When
Mr.
will my
Chairman.
clients, but, Mr. Chair, when will my clients be given full and complete information to review? Because...
I would presume, Mr. Glick,
I sat patiently and didn't interrupt and waited while everybody had their say. I think it's time now that the chair indulge me for just a minute.
we have, wait, hold on a minute. I think I've been more than fair in recognizing you throughout this process. Every time you've wanted to stand or you've raised your hand, I've recognized you. So what we're going to do now is we're going to move on to scheduling the next hearing date. And your concerns have been duly noted by the board, believe me. We will move on to a review of this plan in detail at our next hearing. And to the extent, again, that there are gaps, concerns, critiques, criticisms, they will be fully voiced and heard. And then after that, you and your clients individually will be allowed an opportunity to be heard. But we have to run this through an orderly process. So, having said that, let's move on.
I may make a suggestion for the orderly process then. I don't think you should schedule a next meeting unless and until all of this material is presented by the applicant in a manner acceptable to the board and the town staff.
Most respectfully, trying to align the schedules of 5 board members, 2 professional staff, and peer reviewers without scheduling something now that could be subject to change if there are information gaps and there is a need to move the date. That's difficult to get all these people on the same
You were
page.
required to do a date certain.
So, look,
I'm agreeing with you.
let's schedule a date now, and to the extent that we might need to move this date for some reason that's important and meritorious, then obviously we will consider that.
Thank you, Mr. Chairman.
Mr. Chairman,
Yes.
if I may, yeah, I somewhat agree with Attorney Glick in that you want to know if we schedule another date, if they're lacking in materials, here we go again. Well, if we schedule another date and they're lacking in materials that we have asked for, I don't think it's really here we go again. I mean, it's starting to look bad. So we schedule another date if they are lacking, if in their time frame of the peer review money, which they're supposed to have in 31 days. And if our peer review people don't have enough time or they don't have enough money to do what we need them to do, we schedule another date and we keep it all on track. But I think it's important that we know where each step of the way is, and part of it will be scheduling our next date and seeing where we are.
Yes, except, and that makes a lot of sense. but for the fact that what we're seeing is, again, stuff is just being thrown out as in compliance when it's not even close to being in compliance.
Well, that's-
These waiver
Well,
requests-
Ms. Attorney Glick, I think deciding whether it's in compliance or not doesn't end over there, it ends over here. And I think with our peer review staff that we've chosen, and Ms. Barrett, Ms. McCollum, I am more than comfortable then compliance is not going to be a problem. What comes out of the compliance is an entirely different story, but compliance with what we want, what the town wants, what the peer review people want, what the abutters want, I don't think that's going to be an issue.
All right, so let's talk about a date. Let's begin with Mr. Mueller. I think we're talking September at this point. Ms. McCollum?
Not to prolong this, but if the board wants your next hearing to be engineering specific, if you want the CEI team here, it is imperative that we have the stormwater report. That's really, you're wasting everybody's time having an engineering meeting without that. I also think that if you are having an engineering meeting on the details, that the applicant's team also needs their PE here too. So those are two things that, I don't have the stormwater report right now. I can't, CEI has not seen it in responding to the RFQ. So that is something that, they have 2 meetings in the budget with you. And you don't want to waste them.
So this stormwater report that she speaks of, Mr. Kraus and Mr. Parker, when might that be able to be produced?
I believe that we are looking at the peer reviewer starting in a month. Is that correct, in 31
Well,
days?
what she just said is they're going to need the
At whatever
stormwater.
point it's
Yeah,
paid.
we can certainly have the stormwater report done to the DR 55 standards. Is that what you're looking for? That's subdivision control.
So you either need to do it to the subdivision rules and regulations, the standards found therein, or you need to ask for a waiver and substantiate why you need that waiver.
And
And
it's,
propose what method you will use instead.
I guess it really doesn't matter. We'll stick with the DR 55.
it's our expectation, Mr. Chairman, to move this along, that we're not going to wait the 30 days to provide the funds, because it's in everybody's interest to move this along. So hopefully by the September date that you'll choose, then we can talk substantively about drainage, runoff, whatever the engineers are going to speak about that they find of concern. So,
As I have said now 3 times?
yeah,
You're going to be provided with a memo from Ms. McCollum.
Yeah.
And also bullet points of concern from Attorney Glick.
got it.
And I've tried to indicate, but I suppose it's worth saying once more for the record, it is incumbent upon the interests of the developer in this case to address all of these points.
Understood, Mr. Chairman.
And as you've just heard, we have 2 meetings with our peer reviewers in the contract. So getting the information that this board needs is critical.
Got it.
So we'll push out the next meeting to perhaps sometime in September, which should give you folks plenty of time to get your check-in for the peer reviewers.
Yep.
And also to address these areas of concern or information gaps, however you want to characterize them, so that we can get responses to the memos of Ms. McCollum and Attorney Glick to our experts as soon as possible.
Okay. Mr. Chairman, may I suggest, may I
And as
take
Ms.
the
Clark
risk?
says, just to, not to interrupt, but as Ms. Clark says, in the event that these information gaps, if you will, are not addressed, it's not going to be good for the developer.
Understood.
Well aware.
So, Mr. Chairman, at the risk of suggesting it, the week of the 19th of September, that the 3rd week in September gives us plenty of time. It gets through the Labor Day commotion.
Let's start with Ms. Barrett.
I can't be here that week. I'm actually working out of state that entire week.
I'm going to have to send a subpoena.
The week before?
Actually, I'm not out of state, but I'm out of.
What works for you?
I prefer the week after.
Well, the week.
You're working the whole week, the week of the 19th?
I'm actually, yeah, I'm out in the field overnight for 4 days in a row, so I can't be here.
And
that week.
I'm out of the country the next week, so that's why I was asking for the week of the 12th, if it's at all possible, please.
I can be here that week.
I will not be here the 15th.
I won't be
Just
here
that
the
day?
13th?
The 15th.
So the 13th?
13th is a Tuesday.
I can't be here that night.
That's fine.
The
That's fine.
13th, Mr. Mueller?
I can't be here that night.
You can't be here. What, can you do the 14th?
I can't do the 14th.
You can or cannot?
I cannot.
I can't either. I can be here the 15th, Marlene can't. Do you normally meet on Thursday nights? Is that what you typically
We'll
do?
meet whenever I suggest that it's a night that we can all get together.
Okay. Well, I can be here on the 29th, but I understand you're.
No, I
you're
can't
out
be
that
here on
week.
the 29th.
You can't be here on the 29th.
So does this push us to the first weekend of October?
Can we go to the first week in September? I'm not gonna.
That's very quick.
That's,
That's very quick.
I'll have Joe here, because I'm not gonna be.
Peer CEI will not be here the first week of
Yeah,
September.
that's too
yeah.
quick.
Not gonna happen.
I'll have Joe here.
So maybe the beginning of October.
The first week in October, I'm out of town.
I can be here on the 6th.
I can't.
You cannot.
Ms. Barrett, let's start with you.
I can be, if the first week in October, I can be
No,
here on the 5th
Ms.
or the 6th.
Mello cannot be here the first weekend of October.
Okay.
Is there any other date in September that works for you?
Yeah. Tuesday, the 27th. Oh, but that doesn't work for the attorney. Goodness. Wow. So, you know, I tell you, every month there's a Labor Day or Monday holiday, it messes everything up. The 8th of September, I could be here, but you can't. Is that
It's
We
too
think
quick.
that's too
It's
early
too
for
quick.
CEI.
Sorry, right.
So is it October for you, Judy?
It really looks that way, yeah.
All right, so tell me when in October.
Well, just because everybody else's conflicts too. I mean, like I could be here the last
Right.
week, but it doesn't work.
When are you available in October?
The 4th or the 5th are open in my schedule, which are Tuesday and Wednesday night.
Ms. Mello, is that the week that's bad for you?
Yes. We're gonna
So
be
the
out
following
of
week, Ms.
town.
Barrett.
I can be here on the 12th. I could be here on the 13th.
Does that work for you, Ms. Mello?
Both. Yep, 12th to 13th.
The 12th is a Wednesday.
Maynard, yes.
So,
Both the 12th and the 13th.
He's gone.
You're gone that whole week?
Well, that's, I wasn't gonna say anything, because I would have somebody in my place, because I'm gone for about 3 weeks, on something.
Do you want to have somebody cover this for you or not?
How about I know it'll extend this, the time, and we'll extend the time at that time. How about the last week in October? I'm sorry.
Or we were just going
you
through
mean
the
the week of the
second.
21st, 24th?
The week of the 24th. And that way, we'll definitely have everything to you.
Wide open? Ms. Clark,
I can be here on the 27th.
Get on my calendar now.
27th?
The Thursday?
I'm sorry.
That's a Thursday night. I can be here.
Sure.
Is that good for the members to my left?
that work for
Mr.
you?
Mueller?
Good.
Ms. Clark?
I'm good.
Wow, we found
Ms. Barrett? Ms.
Yeah.
McCollum?
3 months. from now.
October 27th.
Just seems very,
I anticipate that you're going to be asked for another extension,
Yeah, we'll give it. We're gonna give it.
and I trust you on that. I told you that before.
Yeah, we're gonna give it, because, again, my client's not gonna spend $17,000 to,
Right.
not.
So,
Helpful
again,
here.
in recognition of the concerns expressed tonight by Ms. Barrett, by Ms. McCollum, by Attorney Click on behalf of the Neighbors in Opposition and other members of the board, both tonight and previous, it is, again, and I'll say it one last time, incumbent upon you to address all of these information concerns and deficiencies as identified in a memo that will be sent to you shortly by Ms. McCollum and bullet points prepared by Attorney Glick.
Excuse me, when you say shortly, what's the time frame on that?
They will be sending something off to you, I would assume, in the next week. Okay? So,
I won't have mine by the next week, but it'll be shortly thereafter.
okay, so within the next 15 days or thereabouts?
Yes.
Yeah. So you're going to have plenty of time to respond,
Thank you, Mr. Chairman.
Yes.
okay?
We want to be thorough.
But
We want to be thorough.
you want to be thorough, and you want to answer all of these concerns. It's in your best interests.
I understand.
And, Mr. Chairman, excuse me, but again, to the public, it won't be like, you won't get a certified letter if you're in a butter or anything like that. It'll be posted in the town hall for the meeting date and time, and it'll be incumbent on you to kind of make sure that that's all happening. We set the date, so we won't change it or move it up. So it's set for October 27th. But again, you have to kind of keep
I
an
want to
eye out.
thank members of the public. I know
I know.
some of them I observe are on the edge of their chairs, and others are falling asleep, but all of you will be given an opportunity to speak, so thank you for being patient with us as we work through this process. It's highly technical, as you've heard, and requires a lot of study outside of the actual public hearings that go on here.
May I ask a question?
Ms. Barrett?
Between now and that meeting, is it all right with the board if the town planner and I perhaps meet with the peer review consultants just to find out where their thoughts are on this project and perhaps just to help prepare for the next meeting?
Okay.
Is that all right with the board?
Is that something you would recommend, Ms.
It's
Barrett?
typically what we would do,
Okay,
just to
so
try to
let's-
coordinate,
let's-
with them.
Let's put that in the form of a motion.
Ms. Barrett, is it typical that a member of the zoning board could sit in on those meetings?
That's entirely a local decision. It varies a lot. My only comment would be that if you want to treat it as a work session with a member of the board present, I would recommend that you check with town council and make sure that whether town council thinks that it should be posted. I realize that it would not be a quorum, but believe me, for all the towns I work in this capacity, I can't tell you the difference of opinions among town councils as to whether work sessions involving a ZBA member should be open to the public, so I.
Kind of smirking because I have had through the years disagreements with town council, friendly, professional disagreements. as to
I'm
their
not going
opinions.
there, I'm just saying that,
So
I would just,
I would expect that if you have such a
More
meeting, the
observation.
professional staff has such a meeting, that you would put the results of that meeting in some form of memo so that it could be
Absolutely.
circulated to the board.
certainly, we would, absolutely, that would be fine.
I just wanted to.
Just to coordinate with them before the next meeting.
All right, so let's put that in the form of a motion. Does somebody want to make that motion?
I'll make the motion that Ms. Barrett and Ms. McCollum can meet with the peer review engineers.
Yes.
For our next meeting.
Before our next meeting to look over the material that has come in and formulate a plan.
And address any concerns with a memo to be sent to us
That's fine,
thereafter.
absolutely, that's fine.
Is that acceptable?
I'll second.
Any further discussion on this?
Thank you.
All in favor?
Aye.
Next motion would be a motion to set the next hearing date.
Which I think you, oh, that's.
Do I hear a motion to set the next public hearing date for the date of October 27th in this room at 7 PM?
I so move.
Do I hear a second?
Second.
All in favor?
Aye.
Next motion is a motion to adjourn.
Before the motion to adjourn,
Motion to continue?
we're getting fixated, I believe, on these technical issues, which is all good. CEI is going to be looking at hydrology and engineering and wetlands delineation and whatnot, and that's wonderful and it needs to happen. I just want to make sure that there is also time set aside for the board and the public to discuss other aspects of this project. I mean, this project is not designed. It is an exercise in getting 39 lots on a given piece
All
of
right,
property.
so, Mr. Glick, rather than getting involved in argument again on the merits of this plan to address the predicate comments that you just made, I don't know how many different ways I can say this, but after the board receives its report from its peer reviewers and thoroughly digests their opinions and/or critiques, each and every member of the public who wishes to be heard will be heard. And and anybody who has sat in, on any of our meetings over the years knows that I recognize everybody who wants to speak, so long as it's not the same person like 9 times, and so long as the comments do not become repetitive or disrespectful. So the answer to your concern is that, yes, members of the public will be heard about any concerns that they might have.
Well, the one drives the other, that's the problem.
Well, then they will speak to us about that, but that's, I don't, again, I don't know how many more ways I can say it. Everybody will have an opportunity to be heard, everybody will have a voice. So,
Thank you. Did you vote on the?
we're about to vote on the motion to continue, I guess, right?
Make a motion to continue,
To,
October 27th.
October 27th.
yeah. Second,
Second.
all in favor?
Aye.
Motion to adjourn,
So moved.
Second?
all in favor?
Aye.
We stand adjourned. Thank you for everybody's patience tonight. See you in October.